Welcome to the McCabe Centre for Law and Cancer Council Victoria's webinar, New Advanced Care Planning Laws, Implications for Clinical Practice. I'm Jonathan Lieberman, I'm Director of the McCabe Centre for Law and Cancer, and I'll be your host this evening. Our event will be recorded and made available on the Cancer Council Victoria website next week. You may wish to view it again or recommend it to others. Before we begin, we'd like to acknowledge the traditional owners of the lands we are meeting on today. We also pay our respects to their elders past and present and all Aboriginal people participating today. If you have any connection problems during the webinar, please call the numbers on your screen, quoting the meeting number provided, 578-706-224. Tonight's webinar will run for an hour and a half. The first section of the webinar will consist of presentations from our expert panellists and a panel discussion. For those of you who have not participated in a webinar before, you don't need to do anything during this time, just sit back and enjoy the presentations. You may like to have a pen and paper ready to make some notes or jot down questions that you can ask later in the evening. Towards the end of our session, we'll have a live Q&A segment. At this time, those attending the webinar can post a question to the panel using the question and answer function in the webinar software. During question and answer time, the presenters will offer live responses to questions that come in from participants. And a disclaimer, the content in this webinar is general information only. The information isn't intended to be legal advice and shouldn't be relied on as such. The legal information in the webinar is specific to Victoria. For information about advanced care planning laws in other states and territories, we'd recommend that you visit the website that you see on the screen. This is an excellent website maintained by the Queensland University of Technology's Australian Health Research Centre. So why a webinar on advanced care planning? The law in this area hasn't traditionally been well understood. We ran a couple of webinars in 2015 to inform people about how the law could support them to have a say in their future health care. One for people affected by cancer and those who care for them, and one for health professionals. Now that the law has been changed by the Medical Treatment Planning Decisions Act 2016, we're running another 2 webinars to discuss advanced care planning options and the key changes introduced by the new legislation. We ran one webinar last week for people affected by cancer and those who care for them, and this one is for health professionals. Recording of both webinars will be available on the Cancer Council Victoria website. So what do we mean when we talk about advanced care planning? It's a process of planning in advance for future healthcare decisions should a person lose the ability to make decisions. It includes appointing someone to make decisions, thinking about and talking about preferences and values with loved ones and the healthcare team, and in many cases documenting those preferences and values. Existing laws have been fragmented and confusing for those seeking to apply them. The new legislation, the Medical Treatment Planning Decisions Act 2016, creates clear obligations for health practitioners caring for people who don't have decision-making capacity, making it more likely that people will receive medical treatment that is consistent with their preferences and values. It's important to note that the commencement date for the Act, so the changes that we'll be talking about this evening, take effect in March 2018. So we'll move on now to the presenters and then the panel discussion. I'd like to introduce McCabe Centre Legal Policy Advisor Dr. Deborah Lawson, who will talk about advanced care directives and the key changes made by the new legislation.
Thanks, Jonathan, and good evening, everyone. Some of you might be wondering why we're talking about advanced care planning and the law and what the law has to do with advanced care planning. You might think of it of advanced care planning is a purely health or medical issue. So I wanted to begin by highlighting that the law has a role in advanced care planning in two key ways, and that's through enabling people to appoint someone to make medical treatment decisions for them if they become unable to make their own, and through enabling completion of advanced care directives, which are documents that record a person's preferences, values and decisions about medical care. So the new Medical Treatment Planning and Decisions Act 2016 will guide medical treatment decision-making processes for people who don't have capacity to communicate or make their own decisions. Before I get into the discussion about changes to advanced care directives, I just wanted to highlight that the Act changes the terminology in relation to substitute decision makers. So those who might be considered the person responsible for medical decisions under the existing Guardianship and Administration Act will from March next year be known as a medical treatment decision maker, with some minor amendments that Sandra will discuss further shortly. So when I'm referring to the medical treatment decision maker throughout my presentation, I'm referring to people appointed by the person or by VCAT as their decision maker, or people recognised as the decision maker under the legislation because of their relationship to the patient. So what are the key changes to advanced care directives under the new Act? The new Act permits anyone with capacity to make a legally binding advanced care directive, and there are two options for doing this. People can do either one or both. People can make an instructional directive, which allows them to provide specific directives about treatment they would consent to or refuse. And people can make a values directive which details their preferences, values and wishes, which must be considered when a medical treatment decision is made on their behalf. Medical treatment is defined fairly broadly in the new Act to include treatment with physical or surgical therapy, treatment for mental illness, treatment with prescription pharmaceuticals or approved medicinal cannabis products, dental treatment and palliative care, although some of these are treated differently in different parts of the Act. So how does this differ from the existing situation? Currently, only those who have a current medical condition can complete a legally binding advanced care directive, which is called the refusal of treatment certificate. And even then, people can only refuse medical treatment through that means. They can't also provide consent to treatments that they would want to receive. The law has previously been unclear as to whether values-based documents or advanced care plans, such as a statement of choices, were legally binding on health practitioners, although they have always been and will remain strong evidence of a person's treatment wishes. So coming back to instructional directives, in these, people can provide specific directives about treatment that they consent to or refuse. So they might include a statement that they consent to a heart bypass in specific circumstances, or that they refuse CPR in specific circumstances. An instructional directive takes effect as if a person who gave it has consented to or refused treatment, and what that means is that nobody else's consent is required in order for treatment to proceed or to be withheld. However, the new Act does make it clear that treatment can't be demanded in an instructional directive. People can provide legally valid consent to treatment, but only to treatment that a health practitioner is willing to offer them. The values directives will enable people to record their preferences, values and wishes as a basis on which they would like medical decisions made for them, and they can include a statement of medical treatment outcomes that would be acceptable to them. For example, if I'm unable to recognise my family and friends and can't communicate, I don't want any medical treatment to prolong my life. Or if a time comes when I can't make decisions about my treatment, I would like to receive any life-prolonging treatments that are beneficial, including research procedures. And health practitioners must consider the values directive in offering and administering treatment. The consent of a medical treatment decision maker is still required for treatment to proceed in the absence of a relevant instructional directive. So the instructional directive stands in the place of consent, but the values directive will still require a medical treatment decision maker to be involved in the treatment. And the rights and responsibilities of medical treatment decision makers in relation to those documents will be discussed by Sandra shortly. The Act imposes a number of new responsibilities on health practitioners. The new Act applies to all registered health practitioners and paramedics, so not just medical practitioners. All of these groups will be obliged to make reasonable efforts in the circumstances to ascertain whether a person who doesn't have capacity to make their own decisions has either or both of an advanced care directive or a medical treatment decision maker. If a health practitioner is aware of an advanced care directive, they must comply with it except in very limited circumstances that I'll go into shortly. Medical practitioners have particular responsibilities as authorised witnesses to the completion of advanced care directives. So advanced care directives must be signed and certified by 2 witnesses, one of whom must be a registered medical practitioner. Both witnesses have to certify on the document that at the time of signing, the person giving the directive appeared to have decision-making capacity in relation to each statement in the directive and appeared to freely and voluntarily sign the document and to understand the nature and effect of each statement in that directive. So what does this mean in practice? I wanted to go through now the process of reaching a medical decision for someone whose decision-making capacity is an issue, and then Sandra will talk about what happens when a medical treatment decision maker is required to be involved. So the first thing to assess is whether the patient has decision-making capacity, and the new Act provides a definition of capacity, which shouldn't be too surprising to anyone, the elements of the test. Note that there is a presumption of capacity for adults in the Act. Children under 18 aren't presumed to have capacity, but they may make their own medical treatment decisions if they are assessed as having capacity, and they can make advanced care directives also. So the first step in assessing capacity is to consider whether the person can understand the information relevant to the medical decision and its effects, retain the information to the extent necessary to make the decision, use or weigh the information as part of the decision-making process, and communicate the decision and their views and needs as to the decision. If the patient does have decision-making capacity, then treatment may only proceed with their consent, even if death will result from not treating. If the patient doesn't have capacity, then you need to assess whether it's an emergency situation. The rest of my presentation will focus on patients who don't have decision-making capacity. So in an emergency situation, if a health practitioner reasonably believes treatment is necessary as a matter of urgency to save life, prevent serious damage to health, or prevent significant pain or distress, treatment may be provided without consent. In an emergency, there's no obligation to search for an advanced care directive that isn't readily available. However, treatment must not proceed if the health practitioner is aware that treatment has been refused via an instructional directive or a refusal of treatment certificate. Unless the health practitioner believes on reasonable grounds that circumstances have changed since the person completed the instructional directive, so that the practical effect of their directive is no longer consistent with what they would want, and the delay caused by applying to VCAT for an order would result in significant deterioration, in which case treatment can be provided. If it's not an emergency, the health practitioner must make reasonable efforts in the circumstances to ascertain if the person has either or both of an advanced care directive and a medical treatment decision maker. If they find an advanced care directive and it includes a relevant instructional directive, the health practitioner must comply with that directive by withholding or withdrawing treatment that has been refused or administering treatment that has been consented to if it's clinically appropriate to do so. The exception, again, is the same for in an emergency if the health practitioner believes on reasonable grounds that circumstances have changed since the instructional directive was made, so that the practical effect is no longer consistent with what the person would want, then the health practitioner should apply to VCAT for revocation, variation or suspension of the instructional directive. To make one of those orders, VCAT must be satisfied that circumstances have changed, so that the practical effect would no longer be consistent with what the person wanted, or that the person relied on incorrect information or assumptions when they made their instructional directive. Again, if there's no time to apply to VCAT because the patient would suffer significant deterioration whilst applying to VCAT, then the health practitioner may refuse to comply with the instructional directive. But except in cases of emergency, consent would still need to be sought from a medical treatment decision maker for treatment to be administered. If there is no relevant instructional directive, then the health practitioner will need to make reasonable efforts to identify a medical treatment decision maker to make the decision, and the health practitioner needs to give effect to any values directive in offering and administering treatment. And finally, I'll just talk about transitional arrangements and interstate documents. Given that this Act doesn't come into effect until March next year, a refusal of treatment certificate completed under the existing Act will continue to apply in the same way until and after that date, unless it's revoked or otherwise ceases to have effect in accordance with that Act. And other advanced care plans will continue to provide strong evidence of a patient's preferences, views and values, and should therefore be carefully considered by medical treatment decision makers and health practitioners. Advanced care directives made in other states or territories will be recognised in Victoria to the extent that they comply with the requirements in the jurisdiction they were made in, except that they will only have the status of values directives and won't be recognised as binding instructional directives. And it's now my pleasure to introduce McCabe Centre Senior Legal Policy Advisor Sondra Davrin to talk about changes to medical treatment decision-making processes.
Thanks very much, Deborah. And good evening, everybody. Tonight I'm going to go through the key changes the new Medical Treatment Planning and Decisions Act makes to substitute decision-making. And some of these changes are listed here on the slide. So you'll recall some of the new responsibilities for health practitioner from Deborah's presentation, and I'm just going to emphasise those new responsibilities that relate to substitute decision-making, which are the requirement to ascertain that a person has a medical treatment decision-maker before administering medical treatment to a person who doesn't have decision-making capacity, and the responsibilities as an authorised witness to the appointment of medical treatment decision-makers, which I'll go through shortly. So a medical treatment decision-maker is a person with the authority to consent to or refuse medical treatment on behalf of a patient who does not have decision-making capacity. And at the moment, they're known alternatively as agents, guardians, or generally as substitute decision-makers, depending on how they are appointed or whether they are recognised in statute. And under the new Act, they'll all be called medical treatment decision-makers. Medical treatment decision-makers will be able to be appointed under a formal process, or they can be recognised as per the existing legislation. But an important change in the new legislation is that all medical treatment decision-makers will have the same powers. A decision-maker will be able to make a medical decision, which is defined in the Act and is included here on the slide, and this is a decision to consent to or refuse medical treatment. This is in contrast to the current situation where there's a difference between decision-makers who can refuse treatment and decision-makers who can only withhold consent to treatment. So a person can formally appoint a decision-maker at any time, or they can appoint one if and when they make an advanced care directive. So a person can have both a medical decision-maker and an advanced care directive, or they may have one and not the other, or they may have neither. VCAT, which is the Victorian Civil and Administrative Tribunal, can also appoint a guardian with the power to make medical treatment decisions. A VCAT guardian is usually appointed in cases where there is a person with a disability who's unable to make decisions about their personal affairs, including decisions about medical treatment. So just as there are formal requirements for appointing a decision-maker under existing powers of attorney and guardianship law, there will also be formal requirements for appointing a decision-maker under the new Act. And the formal requirements are listed on the slide here, and these are formalities for the person who is making the appointment. However, there are obligations for health practitioners who are acting as an authorised witness. So they're required to witness the appointment and certify that the person has decision-making capacity and appears to understand the nature and consequences of the appointment, and they must also certify that the person making the appointment is doing so freely and voluntarily. If a person has not given a relevant instructional directive or appointed a medical treatment decision maker, then a health practitioner will be required to identify a medical treatment decision maker to consent to or refuse medical treatment. And this is no different from the existing situation. However, the new legislation has consolidated and simplified the list of potential medical treatment decision makers. And on this slide and the next, I've set out the current and the new hierarchy. And as you can see, there will no longer be the different classifications of appointed decision makers. There will only be two types of appointed decision makers, one appointed by a person under the Medical Treatment Planning and Decisions Act, and a guardian appointed by VCAT under the Guardian and Administration Act. And continuing the side-by-side comparison, the new Act loses the nearest relative terminology and shortens and simplifies the hierarchy of family members who may be recognised as a medical treatment decision maker. And as you can see here, the new shorter list is limited to spouses or partners, carers, and the eldest adult child, parents, or adult siblings. The new Act will also require that a recognised decision maker must have a close and continuing relationship with the person that they are making a decision for. So just to recap these changes, all decision makers will have the same powers to consent to or refuse treatment. The list of potential decision makers has been simplified, and there are now only two types of appointed, or there will be only two types of appointed decision makers. The terms person responsible and nearest relative will no longer be used, and those recognised as decision makers under the hierarchical list must have a close and continuing relationship with the person. Close and continuing relationship isn't defined in the Act. It will most likely have to be assessed on a case-by-case basis. But it is designed to ensure that distant relatives or close relatives with no connection to a person will not be making medical treatment decisions for that person. The Office of the Public Advocate are developing guidelines to assist in determining whether a person has a close and continuing relationship. And as a final point, the Act will also allow VCAT to recognise a person as a medical treatment decision maker, even if they don't have one of the relationships listed in the new legislation. For the tribunal to recognise another person as a medical treatment decision maker, they will need to assess that the person has a close and continuing relationship and be able to show that they understand the preferences and values of the person such that they would be the most appropriate medical treatment decision maker in the circumstances. So as well as simplifying the list of who can be a decision maker, the new Act will also change the way that a decision maker comes to a decision. So there are currently different tests to assist medical treatment decision makers, including the best interest test or the requirement that a decision be consistent with the person's values. The new Act changes the guidance for medical treatment decision makers so that they will have to make a decision that they reasonably believe is the decision that the patient would have made for themselves. And the new legislation sets out the steps a decision maker must take when making a decision for a person without capacity, and these are listed on the slide here. And to be clear, these are the steps that have to be taken when there isn't an instructional directive, or if there is a directive but it isn't relevant to the decision at hand. Firstly, the decision maker has to consider any values directive and then any other relevant preferences. If there's no directive and no preferences have been expressed, then the decision maker must consider a person's values and the effects of the treatment and alternatives to treatment, including the option to refuse treatment, to decide which are more or less consistent with a person's preferences and values. And a decision maker must act in good faith, which means they have to act honestly and sincerely, and with due diligence, which in this context means being careful and taking steps to investigate and understand the benefits and risks of a decision. And they must consult with people that the patient would have wanted consulted. If a decision maker doesn't or cannot know a person's preferences and values, they have to make a decision that promotes the person's personal and social well-being, having regard to the need to respect the person's individuality. And according to the Act, this means that a decision maker must consider the effects and consequences of a treatment and alternatives to treatment, including the option to refuse treatment, to determine whether these promote the person's personal and social well-being. And again, they are required to act in good faith with due diligence and consult. If there is no advanced care directive and no medical treatment decision maker, and a health practitioner has made an effort to find both, then there are two options if treatment is to proceed in a non-emergency situation. Firstly, the new Act draws a distinction between significant and routine treatments. Significant treatments are defined as anything that involves a significant degree of bodily intrusion, a significant risk to the person, significant side effects, or significant distress to the person. Routine treatments are those that would not be considered significant according to that definition. And under the new Act, if the treatment is routine, then it can go ahead without the consent of a medical treatment decision maker. But if the treatment is significant, then the public advocate can be the decision maker, and the treatment can only go ahead if the public advocate consents. And in deciding whether to consent to or refuse significant treatment, the public advocate is obliged to follow the same deliberative process as any other medical decision maker. That is, they will have to make a decision that takes into account a person's preferences and values, or personal and social well-being, as outlined earlier. So if there is a decision maker refusing significant treatment and the health practitioner doesn't believe the decision maker knows the person's preferences or values, then the health practitioner must notify the public advocate. And the public advocate decides whether the decision to refuse treatment is reasonable or not, and if not, they can ask VCAT to review the decision. So there are also some provisions in the new Act which allow health practitioners and others, including the medical treatment decision maker and anyone else who can show a special interest in the case, to apply to VCAT for orders relating to medical treatment decisions or to get directions or an advisory opinion. And so just a couple of technical points to wrap up this section on substitute decision making. Firstly, if a person has already appointed an agent or a power of attorney, or has a VCAT appointed guardian, or if they appoint someone before the new Act commences next year, then these appointments are carried over under the new legislation. And if a person has come from another Australian state or territory and has made an appointment there, then it is valid in Victoria if it complied with the law of that state or territory in which it was made, and to the extent that the appointment could be made under Victorian law. And so to discuss more about how these changes will affect clinical practice, it is my pleasure now to introduce Dr. Barbara Hayes, who is a palliative care physician and advanced care planning program clinical leader at Northern Health.
Thank you, Sandra, and good evening, everyone. I want to focus now on some of the clinical aspects of the new legislation. And can I preface this by saying that the law can actually be a good friend to clinicians. Sometimes we worry about being sued and we worry about the law as something to be wary of. However, the better you understand the law, the better you understand how helpful it is. So at a clinical level, much of advanced care planning is actually the same process. However, there are some legal aspects that have changed, as you've heard. They've changed in the direction of greater clarity for interpretation and changed in the direction of giving clear priority to the preferences and values of the patient over the competing interests of others. Some of you may know that at Northern Health and some other settings, we use the concept of advanced care planning in 3 steps using the acronym of ACP, just to help us to remember the 3 generic steps in advanced care planning. And this still applies. So A, appoint another, which is the medical treatment decision maker. C, chat and communicate. It's important that the person who's making the appointment talks to their medical treatment decision maker about the things that that person would need to know to make good decisions for them. They should also think about whether they need to communicate with other family members, maybe with doctors, to get more information. Then some people may need to speak to a spiritual advisor to find out what their faith teaches and what's permissible. And then the P is put it on paper, and that's the Instructional Advanced Care Directive or the Values Directive. It's going to be very important that we correctly identify the medical treatment decision maker for patients and we become familiar with the new hierarchy. consent from the wrong person is not actually consent. We need to make sure that the person we're speaking with is the right person. The medical treatment decision maker is a person with a close and continuing relationship. This is something we may not necessarily know if we don't have an established connection with the patient ourselves. Think of the patient coming into the emergency department for the first time. However, I think where there are ongoing professional relationships, it does help. And one particular situation that I think does crop up is where there are a group of family members who are caring for a patient. Everybody's understanding what the plan is, and then a relative turns up from interstate or overseas who really hasn't had very much contact at all with the patient, but wants to assume decision-making authority on account of being the oldest. And I think with this new legislation, such a person is clearly excluded from being the medical treatment decision maker, and that makes it clear. As you've heard, person responsible won't be a term that we use, and also can I encourage you to not use the term next of kin. As you can see from the hierarchy, there are a lot of people in that list who don't meet the criteria of next of kin, and it becomes quite confusing if we use that term. We now have a statutory duty to discover advanced care directives. It's no longer just a professional or an ethical duty, but it's actually part of the legislation. So we need to ask about and obtain and record previously committed advanced care directives. So we need systems to allow us to do that. And I think we should ask about prior advanced care plans a bit like we might ask about allergies. It's just part of the routine question. We would always encourage the patient and their medical treatment decision maker to offer that information without being asked, just in case somebody forgets, but it is really important that we do ask. So how do we use an advanced care directive? Well, a valid instructional directive provides both valid consent or refusal. We were concerned in the past about advanced care plans having uncertain legal status, and this is no longer the case. And but even if an instructional directive exists and applies, there may be other decisions around this that need to be made by the medical treatment decision maker. So even if there is a valid instructional directive, I think it's still good practice to talk to the medical treatment decision maker and broader family, even though we don't require consent. And I think part of that obligation is the communication is also about caring and supporting the medical treatment decision maker and the broader family. If it's a values directive, then some interpretation is clearly required before we can obtain, and we need consent from the medical treatment decision maker. The more information we have about the patient, the better we as clinicians and the medical treatment decision maker will be able to collectively make a decision that represents what the patient would want. The written document is an important part of that information. There may also be additional information that can be ascertained from others who actually know them well. And of course, the medical treatment decision maker is one of those. But other family, GP, specialists that are involved in their care, and community nurses, to name some, may actually have additional information that contribute. If a directive is unclear or uses vague terms, then it's going to be important to speak to the medical treatment decision maker to clarify what the person might have meant, to actually flesh out what they've written. So, you know, what did Mum mean when she said no heroics? Can you tell me a little bit about what she was most worried about? And I'll discuss in a later slide some questions that might help in that. So valid consent and refusal, as mentioned before, is still obtained from the medical treatment decision maker when there's a values directive. And one of the new aspects of medical treatment in this legislation is the requirement to have consent for medications. And so discussion is going to be very essential always in the setting of a values directive. So I just want to talk a little bit about how I conceptualise medical decision-making and through shared decision-making, which might be helpful in thinking about where advanced care planning fits in. And I think regardless of the existence of advanced care directives, the first step has to be a medical assessment, using medical in the generic sense, but an assessment and an evaluation of the patient and a decision about what might be wrong and what might be feasible in the way of investigations and treatment. So having identified those boundaries, then you can have a shared decision-making discussion, which is a two-way interpretive process, hopefully arriving at a shared understanding of what would be best for this patient, what the patient would want, and to which the patient consents. When the patient cannot be directly involved and the decision has to be made with the medical treatment decision maker, that is when we as clinicians and the medical treatment decision maker all need to take into account prior advanced care planning according to the status and the authority of the document. So the shared decision-making discussion needs to consider what the patient has said, be it an instructional directive or a values directive, again coming to an agreed medical treatment plan. If there's an instructional directive, there won't be a need for consent for that treatment, but there certainly will if there's a values directive. When the person has lost capacity and there's no advanced care directive, I think there's a risk that we throw our hands up in horror and at that point and think, well, you know, we've missed the opportunity. I think it is problematic if there is no medical treatment decision maker or no time to speak to others who know the person. But we can still learn about the person from the medical treatment decision maker and others who know that person. Often these decisions are made on the background of progressive illness. And these are some questions that I think will help flesh out what the values and preferences of the patient might be. So what is the story of this person? Who are they and what has been their illness experience? What matters most to them? Have they said anything about this sort of situation? Establish what the illness trajectory has been and how did they respond at significant points along that illness? How have they been coping? What is the worst part of the illness and what do they fear most and what do they hope for? These are questions that will also help you if you're helping a patient to complete an advanced care directive as well. It's also important when making decisions for patients to learn about the family. Patients are our priority, but they don't live in isolation from family and friends, and they possibly have interests in the well-being of their family in that decision-making. So while the interests of the family are not part of the treatment decision, we do need to engage with the family, helping them understand that we care about the patient and we care about them. Establishing a relationship of trust so they can trust our medical judgment and they can trust that we will have the patient's best interest as a priority. We need to facilitate a situation where the medical treatment decision maker and the family will provide honest information about the patient's own preferences and values, and we need to help them understand that the decision must reflect the person's values and preferences, even if that doesn't coincide with the interests of the medical treatment decision maker and broader family. And this is where a values directive could be really helpful if it says the patient wants the medical treatment decision to make a decision that they could live with, the medical treatment decision, even if it isn't exactly what the patient themselves would make. So there are situations where we as health professionals might really strongly recommend to a person they do complete a written instructional values directive. And I think these are three situations where we would think it would be particularly important. People who have really strong preferences about future healthcare, people who are socially isolated, they have no one to appoint as a medical treatment decision maker, no one who will represent and advocate for them, and where it's clear that there are lots of different views about medical treatment within the family, and it's likely that at a time of decision making there will be lots of different views about what the patient would want and what their preferences would be. Remember that the doctor who's witnessing an instructional directive is testifying to the person's ability to understand the document. And if completing an instructional directive, the patient really needs to understand that they are giving binding consent or refusal. There is no rethinking the decision at the time of deterioration. This is a document that must be completed with precision, and if uncertain about that, they should write a values directive. And I suspect that a lot more people will write values directive than instructional directive. There is no legislated form at the moment for, there is no legislated form for instructional values directives, but there are legislative requirements for a document to be valid. And as we get closer to the implementation of this legislation, I think there will be some templates made available that we can use. Remember, this is a journey. Treatment preferences might change over time as an illness progresses or as life circumstances change. Values are relatively more constant over time than perhaps specific treatment decisions, but how the values are prioritised or applied might also change depending on both illness status and life circumstances. Therefore, don't forget to keep your patients and advanced care directives under review and periodically ask if what they have written still applies or if changes are needed. Finally, know where to get help. With the introduction of the new legislation, there'll be lots of changes, including the process for resolving conflict. In the first instance, those of us who work in large health services will probably have our own guidelines to refer to and our own in-house resources. I think a really useful go-to source of information will be the Office of the Public Advocate's website and telephone advisory service, and also the Department of Health and Human Services Advanced Care Planning website. So thank you, I'll stop there.
Thank you very much, Barbara, and thanks to Sondra and Deborah as well for those excellent presentations. It's now my pleasure to introduce Sam Breen from Eastern Health to join us for the panel discussion. Sam's a dedicated and highly experienced nurse who's committed to the delivery of support and information to families to assist them to advocate for what matters most. Sam is an accomplished presenter, communicator, negotiator and listener, skilled in building strong relationships with stakeholders across medical, nursing, research, education and public sectors. Sam's joining the panel to discuss the impact of the key changes for people affected by cancer. To discuss the impact of the key changes for health professionals. Just before I ask Sam to talk about what those key changes are, perhaps you can just introduce your role and how in your day-to-day practice you do work with people on advanced care planning.
Certainly. Thank you, Jonathan, and for your kind words, and good evening, everybody. So within health services in Victoria, there are different models for advanced care planning. I, at Eastern Health, have a varied role. I actually can support patients and families directly to discuss their preferences for treatment or concerns or worries, and that can be in the inpatient setting or in the community setting. I also assist with education and training of health professionals and really complement what the clinical staff already do. The other big aspect, I think, of any health service role is about the strategy, the organisational preparedness for receiving plans, and also the reporting on activity. So that's something else as well I do in my role.
Okay, great. And so talk us through what you see to be the key changes that the new legislation is going to introduce into your practice.
I mean, there's several changes, and I think for me one of the key things is a streamlining of the hierarchy of who's who in with the medical treatment decision maker and with the family, because it is extremely challenging making sure you're talking to the right person, and at times it can be people say they're the power of attorney, but in fact they're financial and don't have medical. That's a very common thing we find. So I think providing some streamlining and clarity around that is great. The other thing I think really is the change in culture, or change in moving from refusing treatment to actually consenting for future treatment. I think that's a big change. The other thing I think as well is it's really inclusive of the multidisciplinary team and the statutory obligation to ask if there's a plan. I think that's something that there's been increased awareness within health services from the mandated reporting of all episodes of care. So for those who are in my role will know about that. But certainly the other, I think, is the values. The values are really going to be something that's going to really help guide clinical decision making.
Okay, great. So we're going to now have all of our panellists participate in the discussion. I'm going to kick off with a couple of questions, and I'm going to also encourage the panellists to have a conversation among themselves and ask each other some follow-up questions. One of the things that occurred to me listening to Barbara's presentation was the expectation that there'll end up being more values directives than instructional directives. And I'm wondering how that's going to operate in practice for patients, because I can imagine patients may start by thinking that they want an instructional directive, and then the conversation with the medical practitioner who needs to witness it may evolve in quite an interesting way. So can you explain why you think we'll end up with more values directives?
I think sometimes people think, well, I wouldn't want a particular treatment, or I would want a particular treatment. But once you start talking about it, then you can start to say, well, maybe I would want it if circumstances were like this. And, you know, the absolute binding nature of the instructional directive, I think, might just make people a bit nervous that there's no opportunity to reevaluate in light of, you know, new information that's become available. I think there's no reason why you can't write within a values directive that I wouldn't want to have this treatment, or I would want this treatment, but I would leave it to my medical treatment decision maker to just, you know, make the final decision based on all the information that's available at the time. We do see some people who are absolutely adamant that they don't want a treatment when they do their advanced care planning, but when you talk to them about completing a refusal of treatment certificate, they sort of say, oh, no, I don't think I'll do that. And I think people do just worry a little bit about the fact there's no, you know, review, no wiggle room within that document.
Sam, do you want to comment on that?
Yeah, I would just like to add, one of my concerns when I speak to patients is that, particularly if they have quite a fixed idea about what a treatment entails and the potential side effects, and to give an example, chemotherapy is often something that a person will say, I don't want to have chemotherapy. And I actually sort of almost talk about, you don't want to be undertreated, because, you know, there's new generation medication, you may not have the same side effects, and to be open to discuss it with your oncologist. I think one of the things is that people now having medications in there will open up another option for people to really talk about their treatments. But I'm really keen that people, if they do refuse treatment, do a refusal of treatment certificate, so they're really clear. But I'm really pleased about the values, because often if a person, it's really what outcome they want and are they willing to receive treatment. I think it's going to be really, but again, it's early days. We'll have to really wait and see how it applies.
I think a point needs to be made as well that substitute or medical treatment decision makers aren't just bound by what's in a values directive. So it is important to put the important things into a values directive about perhaps what treatment or you would or would not want. But a medical treatment decision maker can also make decisions based on expressed wishes and preferences, whether they're expressed in a values directive or whether they're expressed otherwise. So I think it's really echoing what Barbara said. It's about recording things that are important to you, but also continuing to have that conversation, and particularly having that conversation about what your wishes and preferences are with your appointed medical treatment decision maker, or with somebody who is close to you, who might be in the position to make decisions for you when you're not able to.
Okay.
I would just add too that oftentimes a patient will say they don't want a particular treatment or they would want a particular treatment, and the question always to ask is why. It's understanding the reason, because that helps you start to understand the thinking behind it. And I think the why is a very important thing to know.
Yeah.
So that conversation with the patient has to start somewhere. And again, going back to one of Barbara's slides about knowing when to, as a practitioner, when and how to initiate that kind of conversation with the patient. So do Barbara and Sam want to comment on how you know that it's time to have that kind of conversation, and then how having a more formal set of processes might change that conversation in the future. Hopefully how it might make it an easier conversation to have.
I think that, first of all, for people with significant illnesses and chronic illnesses, the whole consent process for treatment should actually be engaging with providing information about treatment options, side effects, benefits, and sort of engaging with that decision-making process. In a way, sort of teaching the patient how to think about medical decision-making. Then I think it becomes a more natural transition to think, well, if we couldn't have this conversation ourselves and someone else had to have it, would they know these sorts of things? I think there are some natural times to talk about advanced care planning. I think certainly when you admit a patient to a new program, it's an opportune time to ask if you've done any advanced care planning, and then you can follow that conversation on with, well, explaining about advanced care planning and, seeing if that's something that would interest them and give them information. I think there are also some times when, if a patient is expressing some concerns about the future, expressing concerns about, the sort of social family relationships and perhaps conflicts that are coming up. These are natural times to actually talk about where advanced care planning might actually be something that might help, as opposed to, well, here's something that is just, an add-on extra thing to do, but it's actually something that might be able to help you with your concerns.
And there are some well-recognised clinical indicators for when to initiate discussions, and, things that could be frequent admissions to hospital, frail, chronic conditions. But I would say that one of the things, I think, is just simply to ask. A lot of people haven't heard about it. They don't know they can do it. And often a trigger can be actually something quite personal: divorce, separation, migration, all of these things that naturally happen in life. So I think it was on one of your slides, Deborah, that it's ready at any time the person chooses. But I think we just need to keep offering in health services across the continuum opportunities for people to talk about things. I think that's what we've got to do.
So let's turn to the role of the medical treatment decision maker and the role that health professional can play in supporting when decisions need to be made. Take the case where there's no instructional directive, so how you can best work with the medical treatment decision maker, and I guess particularly again the value that the values directive might play in having that relationship with the medical treatment decision maker.
I mean, I think we're so polite, we're waiting for each other to speak. For those of you who can't see us, that's why the pause. Look, I think it's a challenging position to be a medical treatment substitute decision maker, or whether that's recognised or appointed, if the person hasn't told you their wishes. And I think one of the things is that at times it can be uncertain of outcomes, and I think that uncertainty as health professionals, you know, that's our key role, is to actually to say this is a time where we think this applies, and this is what our understanding of what what you're told us about. I use me as an example, as Sam has said or Sam has documented. This is what we're thinking, and this is what we would recommend, and then we work together. I think that shared decision making is really good, but again, it's really important to understand that there's still a family member first often. And, you know, they still might struggle with being in that role.
I would also add, I think, remember that decision-making capacity is decision-specific. So you have to first assess whether, in fact, this patient lacks capacity for this decision, with the presumption always in favour of capacity unless proven otherwise. If the patient lacks capacity, then we need to explain to the medical treatment decision maker that the person, you know, isn't able to fully make their own decisions. It doesn't mean to say they shouldn't be involved in that decision making as much as they're able. They shouldn't be excluded, but that you know, we need to actually be guided by you know, their instructional directive if they've made one, or we need to engage with the medical treatment decision maker to make a plan based on what we know of the person.
Okay, we're fast coming towards the end of this part of the webinar. I'm going to offer panellists an opportunity to make a final closing comment each before we head to the Q&A session.
I had a question rather than a comment, but we won't have time. So my comment would be just thinking about, I thought that was great, Barbara's point about if there's some hesitation in making an instructional directive, that you can include medical decisions in your values directive, but then leave that discretion to the medical treatment decision maker. And it made me think that you can also put in your values directive other people that you would like to be involved in decision making for you. So you might formally appoint one medical treatment decision maker, but a values directive gives people the freedom as well to include please consult with my other child or my youngest child as well in that decision making. So I think that's important to know too.
I would just say that the medical treatment decision maker has a really important role to play in this scenario, and I think for health practitioners there's a real opportunity to support them and provide, I guess, positive support and information on which medical treatment decision makers can come to the best decision, and then it should be looked at in terms of giving the same support that you would give to the person who would ordinarily be making that decision.
And I would say there's going to be, there's resources being developed by the Office of the Public Advocate and the Department of Health, and I think that will support health services and clinicians to understand in practice what is happening, and also to help educate their cohort of patients.
I think the new legislation creates a nice opportunity to actually talk about consent and decision making and eliciting values and beliefs, etc., and advanced care planning. So I think it just creates a nice opportunity just to look afresh at this space and do education, both of health professionals but also of the community.
Okay, great. So I think we can bring this part of the webinar to a close on that very optimistic note, that it's a real opportunity to continue to enhance the kind of conversations that we're having and to empower patients, their families, and health practitioners as well. So let me thank all of our panellists, Deborah, Sondra, Sam and Barbara, and also Wendy and Sally Ann, who are here with us. We're going to move to the Q&A session now. For those who are staying on for this session, get your questions ready to be answered by our panellists. If you asked a question when registering that we didn't cover in our presentations, we have had a look at in the presentations or in that panel discussion. Please feel free to ask it again now. The Q&A webinar function has now been turned on. To turn it on at your end, click on the Q&A icon. You can see an image of this at the right of our slide. It may be at the top right or bottom right corner of your screen, depending on what kind of computer you're using. When you'd like to ask a question, please enter your question in the text box at the bottom of the page. Your question won't be submitted until you press send, so please make sure you do click send after each question. Questions will be answered by our panellists throughout the discussion time. So we'll now transition to the Q&A session. The audio will be switched off shortly. Thanks very much to everyone who's joined us tonight, and please could you complete the exit survey when you're finished. Thanks very much.